So thank you very much for coming to this presentation. As Ellis said, we're going to talk about sort of employment law and some of the sort of key things to think about. Before we start, though, a quick overview of who I am. So I'm the founder of Buckworths. Before setting up the firm, 12, 13, 14 years ago, I worked on the dark side of law, so doing sort of £500 million plus M&A, so buying and selling listed companies. I think 13 and a half years ago, I set up this firm, and it primarily came about because I had started working with startups in my previous firm, really got the bug, really enjoyed it, and wanted to do some more startup stuff. You know, more than 10 years later, we work exclusively with startups, so it's sort of everything that we do. It's a little bit of a loose term, so it's everything from sort of founders pre-incorporation, so thinking about the business they're going to set up, all the way through to selling clients. The sweet spot for us is sort of slightly earlier stage. So most of our clients are sort of at the top of the range, are sold at around about sort of 200, 250 million. Quite a lot of money if you can get it, but actually in the grand scheme of things, relatively small for the sort of startup market. So in terms of what we are going to talk about, we're going to run through the topics on the screen. So starting off with just a little bit of stuff about tax, because it sort of feeds into a couple of other topics, having a think about the difference between an employee and a freelancer, thinking about sort of right to work, employment documentation, and types of employment relationships, and then having a little bit of a think about some specifics, so pensions, restricted covenants, how you dismiss employees, and finishing off with just some thoughts about what's going to change, and really thinking here about, you know, we're 2 weeks away from a general election. There's very likely to be a change of government, and I think there's a bit of clarity coming out now as to what Labour are planning to do in terms of employment law changes. So we'll quickly touch through those. So to start at the beginning then, when you employ your first employee, you will need to register for PAYE. So PAYE stands for Pay As You Earn, and it's the government's sort of online software to file reports about your employees, how much you're paying them and how much tax you have to pay. And then the taxes themselves are, they can be paid through HMRC's platform, where you can pay it manually, but effectively everything is recorded through the PAYE system. You probably all know that at the end of each month, you don't pay your employees their full salary. What you do is you deduct from their salary income tax and national insurance on their behalf. So that's the sums that nominally they would have to pay. You deduct that from their salary and you pay that to HMRC. What you may or may not know is that you also, as an employer, pay employer contribution national insurance, and that's roughly 13.8%. So if you've got an employee and you're paying them nice, easy numbers, 100,000, it's costing you 113,800 each year because you've got that additional employer's contribution on top. You have to file online reports to HMRC every month, so telling them how much the salaries for your employees are and how much tax they have to pay. And then you have to pay the tax monthly or quarterly, depending on how much tax you're liable for in terms of PAYE. It's actually a relatively straightforward process. Some of our clients do this stuff themselves. It isn't particularly complicated. Some of our clients get accountants or bookkeepers to do it for them. Either way, it is a relatively straightforward thing. What I'll just flag here, it's a massively complicated topic there, so I'm just going to flag it. If you give shares to employees, those shares are taxable, and in essence, they are taxable in exactly the same way as cash. So you have to remember that giving shares to employees is going to generate tax liabilities, probably for you as the employer, but potentially also for the employee. And you do have to declare the issue of shares to employees or the grant of options to HMRC. So when you're doing stuff with shares, just remember that there's a bunch of sort of tax and reporting obligations that go with it. I wanted to just distinguish, and it's a really important point and becoming more important, the difference between an employee and a freelancer. So we all sort of, I think, know what we mean by employee. So an employee is somebody who is working for your business and you exercise a high degree of control over them. So if you think about standard employment relationship, employee has to be in the office from 9 to 5. They have to do what they're told. So if you think about, I don't know, barista and Pret, they have to make the coffees when they're told to do it. If they're asked to I don't know, help on the checkout, they have to do that. So they have a very low degree of autonomy in sort of a traditional sense. They also don't take any risk. So if you think about an employee, you provide all the equipment for them. If they screw up, it's their employer's responsibility to pay any damages, not theirs. So there's very little risk that employees take. They also get paid holiday pay, sick pay, maternity, paternity pay. So there's sort of lots of benefits that go with it. So that employment relationship, you do all of your reporting and tax deductions through the pay-as-you-earn system, as we just talked about. If we look at a freelancer, so in the purest sense, a freelancer is very different. So a freelancer has a lot of control over when they work, where they work, how they work, and who they get to do the work. So if you think about, a freelance lawyer, let's say, that lawyer will be free to do the work at their house, perhaps in their office, or perhaps even on a beach somewhere. They can do it when they want to do it. So you're not saying to them, I expect you to work from 9 to 5. You're saying, I want this document drafted. As long as I get it by 5 o'clock next Monday, don't care when you do it. And they can figure out how to do it. So, you're likely to be less prescriptive probably with freelancers. Freelancers take a lot of risk. So they're not paid if they're sick. If they can't work, they don't get paid. They also have to provide their own equipment. They have to often be insured. So there's a bunch of cost and expense there for freelancers. Now, the difference in pay for freelancers is that they issue an invoice to the company, and that invoice is paid free of deduction. So you don't hold back any tax from that invoice, you just pay it. The freelancer has to file a tax return at the end of the year. So generally, often we're doing it in January, and they pay the tax every year. So if you think about it just from a simplistic perspective, with an employee, HMRC is getting the tax every month, and actually they're getting more because they have an employer's contribution national insurance as well. With a freelancer, they have to wait an entire year potentially to get the money, and they actually eventually get paid a little bit less. So over the years, governments have built in provisions that allow HMRC to reclassify freelancer relationships as employment relationships. So if you have a freelancer, you're paying someone as a freelancer, but they're working in an extreme case 5 days a week, 9 to 5 in your office, and you're basically treating them like an employee, you run the risk of HMRC reclassifying that and saying, well, actually, no, this person, you may have classified them as a freelancer, but this person is an employee. If they do that, then the employer is hit with a bill for all of the PAYE deductions that they should have paid had they correctly classified the freelancer as an employee, plus penalties, plus interest. And the crucial point here, the problem, is you have already paid those sums to the freelancer. So you paid 100% of their salary to them, but you now have to pay the tax that they owe on top to HMRC. What we do in contractor and freelancer relationships to minimize the risk of this is we put in place an indemnity, which basically says if this happens, the freelancer will repay the tax. But to be clear, it doesn't get you the whole way there. So you want to avoid these sorts of issues in the first place. The other thing that can arise, if you've got a freelancer who's reclassified as an employee, you can end up with a whole bunch of employment law claims as well. So they can claim they've been unfair dismissed. They can claim that they've been discriminated against. You can really land yourself in a load of problems. So I think crucial point here, think very carefully whether someone's an employee or a freelancer. Get professional advice if you're not sure, but you don't want to wing it. And particularly going forwards where I think both the Conservative Party and the Labour Party are saying that they're going to be a little bit more proactive in sort of clamping down on this stuff. In terms of right to work, the headline point here, and probably a good opportunity to scare you, if you employ someone who doesn't have a right to work in the UK, then you're going to get fined £10,000 per employee who doesn't have that right to work. And it isn't a case of they don't find startups or they'll fine you a lesser amount. 10,000 quid is pretty much standard and they will fine you. So you really do need to worry about right to work. The principle is fairly straightforward. So in order to work in the UK, you must have, an employee must have the right to work. So for EU nationals, so for British residents, people with British passports, we have an automatic right to work. For EU nationals, they need to have either leave to remain or settled status. And if they have that, then they'll have a right to work as well. For non-EU nationals, what you're looking at is you're looking at their residency visa or potentially leave to remain. But you must just be careful. Just because somebody has a visa to be in the UK does not mean that they can automatically work here. So visas come with restrictions. Student visas, for example, very often they either aren't able to work at all, or they have limited hours that they can work. It is your responsibility as an employer to understand any limitations and get it right. It's no defense whatsoever to say, I didn't realize, they're going to fine you. So in terms of the criminal offences, it is a criminal offence to employ a person in breach of immigration rules and to fail to carry out appropriate due diligence. So at the very basic level, what you should be doing is you should be doing a right to work check. So what that is, that the link is at the bottom of the screen there. Essentially, the employee provides a bunch of information into the gov.uk website. They get a code, they give you that code, and then that gives you an online page that confirms if they do or don't have a right to work. You should always print that report and save it to the employee's file. You should also just make sure you've noted whether there's any time limitations on it. So you could have an employee who is on a visa that allows them to work perhaps full-time in the UK, but that visa expires in 6 months' time. So in 6 months' time, it is possible they will no longer have the right to work. So you need to keep an eye on this kind of stuff and track it. One point just to be aware of, a lot of people think when we're talking about right to work that we're talking about right to paid work. Just be super careful with interns. We'll talk about it in a sec, but be very careful with interns because technically in most circumstances, interns do need a right to work as well. So don't assume that because you're not paying somebody that they can work for you if they would otherwise not be allowed to in the UK. So, essentially check interns and people who are not being paid in exactly the same way as you would employees. In terms of documentation, there's potentially lots of different bits of paper that fly around when you employ people. But I think the main ones that we tend to think about are the ones on the screen. So normally you would send out an offer letter to an employee saying, we'd love to meet you, we want to offer you the role, and you define the name of the role, the key sort of responsibilities, the job description effectively, the salary, any benefits, and any sort of other relevant points. So perhaps if it's a role just for a 6-month term, you would be putting that in the offer letter. Offer letters are non-binding normally, but you do want to try to put into that offer letter the key provisions, because if only you don't want to suddenly find that you've gone through all that effort of getting an employment contract drafted up and getting the employee onboarded and find that actually they don't accept because there was something you missed out. So offer letter important to try and get that right. The most important document though is the employment contract. So that sets out all of the terms of their employment. You have an obligation, a legal obligation as an employer to set out employment terms to every single employee. That's normally done and should be done through an employment contract. And then you've got a bunch of additional stuff. So you should have an employee privacy policy. That will cover both employees and also applicants for roles with your business. And it basically is telling those employees what you're going to do with their personal data. So when somebody applies for the job, in an ideal world, you want to put in the job description or perhaps in a confirmation of an interview or something like that, that their personal data is processed in accordance with your privacy policy, which would be the employee privacy policy, not necessarily your normal business one. And then that employee privacy policy sort of flows through once they're employed and working for the business. Staff handbooks are arguably the most important thing that you actually have beyond the employment contract. So the staff handbook sets out all of the sort of background policies that cover sort of employment law. So what happens if someone gets pregnant? What happens if somebody is going to go on adoption leave? What happens if somebody's going to get fired? Expenses, all these sorts of things. They're all in the staff handbook. And so it's important to have a staff handbook and make that available to your team. And then two final things, bonuses and option and equity grants. It's better, indeed, in most cases, pretty crucial, not to put details of bonus schemes and option equity grants into an employment contract. If you do, they become employment entitlements, so contractual entitlements. And if for whatever reason you don't pay them, or perhaps you fire somebody and you don't want to pay them, they can take you to a tribunal and claim those sums from you. So generally, for most businesses, for most roles, bonuses are discretionary. So you pay a bonus based on a range of factors, performance, and those factors are judged by the employer in its reasonable discretion. So it's not a contractual entitlement. So if that's what you're trying to do, keep it out, do it in a separate policy or a side letter, something like that, to avoid it becoming a contractual entitlement. In terms of equity and option grants, when you grant shares, as we said earlier, to employees, you generate all sorts of potential tax liabilities and reporting obligations. You never, ever, under any circumstances, want to put information about option grants into employment contracts. It's an extraordinarily bad idea for a number of reasons. So those will always be separate documents. So you're talking about option agreements of some kind, or perhaps if you're going to issue shares outright, subscription agreements. But that's very sort of separate from the rest of the employment documentation. Now, the reason why we keep bonus and equity stuff outside of, and also staff handbook policies, outside of the employment contract is because there's a slightly different treatment for those things to what there is of an employment contract. So an employment contract is a contract, it's binding on the party, so the employer and the employee. And due to the way that employment law works, there are some quite complex rules on how you amend an employment contract. So just as an example, key term of employment is the salary. You're going to pay somebody $50,000 a year. You can't, as an employer, just unilaterally wake up on Monday morning and decide you're actually going to pay someone £25,000 a year. If you need to reduce someone's salary, you have to go through a consultation process. There's a bunch of stuff you have to do to make sure that that change is done in a way that's fair. So employment contract contains the binding stuff. The handbook, bonus scheme docs, option grants, all that stuff is separate, and it's viewed more as guidance. So things in your staff handbook, within reason, you can change. So for example, something we were doing with a client last week, they had a policy in their staff handbook around holiday. And so their rule was that employees had to give 3 days notice in order to book a holiday. So if you want to take a day's holiday, you have to give at least 3 days notice to book it. What they were finding was that this was causing huge amounts of disruption because people were booking coming in on Monday morning and saying, I'm going to be off on Thursday and Friday, and they weren't able to sort of balance workflows to cope with that. So what they did is they changed the policy so that people had to give 2 weeks notice. Had it said in the employment contract that this was a contractual term, then we would have been worrying about what we would need to do to change the employment contract. Because it's in the staff handbook, it's essentially just a case of notification. So notifying employees that the handbook has changed. So it's important to sort of segregate contractual points from guidance, and guidance wants to go in the handbook. And I think the way to summarize it is what I said on the screen, that where you want to exercise a degree of discretion, you want that to be in the handbook or perhaps in a separate policy, whether it's bonuses, options, equity, that stuff. So discretionary stuff, ideally outside the employment contract. In terms of executing particularly employment contracts, they must be signed. It's astonishing how often we find companies or employers who have sent employment contracts to their staff, but they've never signed them. There's lots of ways that employment contracts can come into force, and they don't necessarily have to be signed, but it's a hell of a lot better for them to be signed. And there are provisions in there that won't work if you don't have a signature. So always try and get your contracts signed, and frankly, try and get them signed before the employee starts work, or at least on their first day. So don't let this stuff sort of run out, because it's going to come back and bite you in the backside. Employment contracts are often executed as a deed, and all that means is that they're signed by each party in the presence of a witness, and the witness basically puts signs themselves and then puts their details in. I think the crucial thing to just be careful of with deeds, the witness must watch and be present when the person signs the document, and then they complete their details. So you need to be a little bit careful how you execute deeds on DocuSign or sort of similar online signature platforms. You need to make sure that people are genuinely in the same place and that they're genuinely signing at the same time. So just be a little bit careful of that. I would suggest with employment contracts, you're going to have hopefully the employee in the office at some point, get them to sign it with you, get somebody to witness the signature. So it's done in wetting. That solves any debate in the future about enforceability. So in terms of types of employment relationship, employment contracts and employment relationships come in all sorts of different forms. You have interns, you have sort of contract workers, so people who are working for a fixed period of 6 months. So if you think about when a lady's gone on maternity leave, you'll quite often take in a replacement to sort of cover that role during her maternity leave. So that will often be on a contract basis, so it's just for a period of time. You have permanent employees, permanent employees, you can be full-time or part-time. You can have sort of contract employees, you can be full-time or part-time. And then we have zero-hour contracts, which are effectively contracts where you're not guaranteeing to give any work to the employee at any particular time, but you're saying if there is work, then you'll give them the option to accept it. I wanted to just focus on 2 types of contract where things can get a little bit difficult. The first one is interns. So in the UK, by default, you have an obligation to pay anybody doing work at least national minimum wage, and that applies equally to an intern. So if you don't want to pay your interns, you're going to have an unpaid intern in your business, then you have to get the right contracts in place, and that is effectively a volunteer agreement. And so what that is it's an agreement that is not binding. So the intern has no obligation whatsoever to come into work or indeed do any work. So it's entirely voluntary, and there are agreed educational objectives of the internship. So for example, you know, we as a law firm, we may decide that we've got somebody who's a law student, they want to get some experience. So they'll come in, we will give them interesting stuff to do, and they'll be able to sort of put that on their CV going forward, saying they've done all this cool stuff. The crucial point, as just to reiterate it, they don't have an obligation to come in. So if after a day they decide they've had enough and they want to go and sit on a beach, that's entirely their prerogative. So it is very much non-binding. Just as an extension to that non-binding thing, it can, as a result, be very difficult to actually own the content they create. So if we think about intellectual property ownership, we would generally want to own the intellectual property that our employees create for us. With interns, that can be difficult. Sometimes you just wouldn't want to go there because these are voluntary relationships. And if you're taking the work product that they create, that can cause problems. And I think the final thing is, as I touched on earlier, with interns, you do still have to comply with right to work obligations. So you still need to worry about visa status and all of that kind of stuff. The other one I wanted to talk about was zero-hour contracts. So you've probably heard politicians go on about these constantly, and they're awful and they're evil and they're dreadful. There's a little bit more to it. So in its purest sense, a zero-hour contract is a contract that says that the employer has no obligation to give you any work, but they will offer work to you if they can. And then you have an opportunity, if you wish, to take up that work. So it's almost like sort of project work. The crucial thing is that employees are generally only paid for the hours that they work. And that's sort of where the problem comes in. So way back when, businesses like Uber and these sorts of people, what they were doing is they were saying, we don't have an obligation to give you work, but we require you to be available for work. So in essence, you need to sit at home all day, hoping work will come in. You can't go and work for somebody else. And we as the employer have a discretion to give you work if we want to. And there's a whole bunch of case law that says that that basically doesn't work. There's also sort of been some case law that has implied or actually imposed employment protections on zero-hour workers. So there's lots of issues with zero-hour contracts. And as we're going to talk about, the Labour Party, assuming they form the next government, are looking to introduce some significant changes to the way that these work. I think my advice with zero-hour contracts would be, you need to be really careful. You need to make sure that you have got legal advice about the type of zero-hour contract that you're putting in place. Some of them are allowed, some of them effectively aren't anymore. So you do need to be careful. And I think as a sort of good citizen, you want to be thinking about how you can give your employee or your worker the best sort of opportunity to earn a living. So things like exclusivity, they can't work for other people, frankly, are objectively unfair in most circumstances. So being aware of these sorts of issues, I think, is quite important. In terms of pensions, I've introduced this and included it because pensions are essentially very boring and something that is probably not the most exciting thing to talk about, but they are actually a little bit complex and a little bit counterintuitive, and I think they can catch people out from time to time. So, as an employer, you have an obligation to provide a workplace pension scheme for all eligible staff as soon as they start working for you. So workplace pension schemes are, if you like, sort of the basic level of pension. They are provided, there's a whole bunch of providers of them. The government actually have their own provider called Nest. But what they do is they are a structure that allow the employer and the employee to pay a certain amount of the salary into a pension each month. The tricky bit is you have an obligation to automatically enroll every employee who meets the criteria into your workplace pension. So you do that even if they don't want you to. So super important, you have to enroll them into the scheme. The employee can then, if they wish, elect to remove themselves from the scheme. And they do that basically by notifying the employer after the automatic enrolment that they don't want to be part of the scheme. If they do it within a month of automatic enrolment, then they get a refund of their initial pension contribution. If they do it later, then they don't get a refund in most circumstances, but they don't have to continue paying in. So a lot of employers think to themselves, this employee's told me they don't want to be enrolled into the pension scheme, so I'm just not going to enroll them because it saves a whole bunch of hassle. You must not do that. You must enroll them, and then if the employee makes a formal request, they can come back out again. It's a little bit crazy and a bit counterintuitive. The reason is the government are trying to encourage people to have pensions, and I think their logic is if everyone's auto-enrolled for in the first place, most people won't bother to come back out of it. I think that must be the logic. So it's a bit counterintuitive, but you do need to auto-enroll. In terms of who you have to sort of contribute pensions to or having a workplace pension, it's basically all staff who are aged between 22 and a state pension age, which is embarrassing. I don't know what it is, like somewhere between 65 and 70, I think, and earn at least £10,000 a year and normally work in the UK. So you do have an obligation as an employer to understand how much people are working. You can track that through their tax code. And if they are meeting these requirements, then you do need to auto-enroll them. The obligations apply to all types of contracts, so part-time, full-time, and seasonal workers. So, you can't just say this is a seasonal worker who's working during some holidays, therefore I don't need to worry about it. It applies to everybody. And a crucial point to remember, once you've set up your pension scheme and your employees are auto-enrolled, you have to provide a compliance certificate to the regulator within 5 months of the setup of the scheme. If you don't do it, you will get a fine. You also need to revisit any employee who has opted out of the pension scheme every so often. I think currently it's 2 years, but don't quote me on that. But you need to check it. Actually, it might be 5 years. You need to check it every so often to bring them back into the scheme. So you basically auto-enroll them again, and then they can auto-enroll back out again. As I say, counterintuitive, but super important. I wanted to talk about non-compete provisions. Just because these are, A, it's an area that I think is about to change, but B, it's an area that causes confusion and problems for people. So, important background, all of your employees owe an overarching duty of good faith to you as an employer. So they should not, and you can stop them, giving your information away to competitors, working for competitors, poaching clients, all that kind of stuff. It's all covered by a statutory duty of good faith. In your employment contract, you will also have confidentiality provisions and IP transfer provisions. So the confidentiality provision will say you will not disclose confidential information, And if they breach it, there's a breach of contract. Your IP provisions will say any intellectual property that they create belongs to you as an employer, and they can't use it for any purpose other than their employment. So you have or should have those rights in your employment contract. What a lot of employers will do is they will then add in additional restrictive covenants. And these are basically things that are about thinking about non-competition, things that will damage the business. The big problem, the challenge with restrictive covenants is you cannot impose obligations that represent a restraint of trade. So the idea here is employees must be able to earn a living. And if you have imposed restrictions on them that apply post-termination of their contracts with you that stop them getting a job, then in essence, those restrictions are going to be unenforceable and you won't be able to enforce them against the employee. So what you need to think about if you are imposing post-termination restrictions is how can you limit them to cover just the things you need protected. So what you will usually be doing is you'll make sure that the restriction is itself reasonable. You'll limit it by time, geography, and scope. So let me just give an example. We have lawyers in our firm, right? For obvious reasons, I don't want them to move to another firm and start poaching clients because that would damage the business. So what can I do? I can put in place a provision that says you will not contact any of our clients for a period of, 3 months, 6 months after termination of your employment. That's probably fine. What I can't do, I can't put in place a provision that says you want to go and work with one of our competitors for 1 month, 3 months, or 6 months, because bluntly, that's going to stop them getting a job, right? I could define our competitors as any law firm, and London being London, frankly, most law firms are our competitors. So that sort of thing is simply unenforceable. If you do want to do something and impose a restriction that would stop somebody getting a job, you can sometimes pay them for that restriction. So in a very simple sense, if I wanted to say to my employees, you cannot go and work in another law firm for 3 months after termination, I could then pay them for that right. So I could pay them their salary for 3 months, let's say, or perhaps more than their salary for 3 months. So there are ways of making those provisions more enforceable, but in essence, you just need to be aware of this restraint of trade point. In terms of sort of restricted covenants that you're perhaps thinking about, so you can't nick employees, you can't go and poach employees into a competing business. You can't solicit the supplier or customer to reduce the business that they are doing with the employer. So this is not saying you can't work with any of our suppliers. It's saying you can't get the suppliers to reduce the amount of work they do with us. And that, as you can see, is a different thing. It's a little bit more flexible. Potentially, you can say you can't work with ideally a list of customers or specific categories of customers, or perhaps customers with whom the person has worked in the last, say, 6 months in the course of a competing business. So we're not saying you can't set up a competing business or work in a competing business. We're just saying you can't work with this category of customers in a competing business for a period of time. Most businesses are putting about 6 months. Bluntly, more than 6 months for most employees is going to be unenforceable. There's been discussion in government, and I think the Labour Party have also been talking about this, about reducing that period to a maximum of 3 months going forwards. The one that is difficult and frankly is often unenforceable is the one at the bottom in square brackets, that you can't set up or be involved in a competing business. If you've got someone very senior, so CEO, COO, those sorts of really important people, it's possible you could build that into an employment contract. But for most employees, people who are less senior, that's almost certainly going to be unenforceable. So I guess the message on restrictive covenants is probably talk to a lawyer and understand what is enforceable and what isn't. Some employers, by the way, take the view that they're going to put in place provisions that they know are unenforceable, but they are sort of banking on the idea employees won't realize that, and they want to set a line in the sand and say, this is our expectation. There's nothing necessarily wrong with that, as long as you understand the limitations of it, that you're not going to be able to enforce those provisions. In terms of dismissing employees, this is always a tricky area. And I think my starting point here would be, before you dismiss anybody, pick up the phone and speak to a lawyer, because it's possibly a really simple 2-minute conversation where, you call me and I say, yeah, look, ask a couple of questions, this is fine, do X, Y, Z. Or it could be a lot more problematic, and we could be saying, well, actually, stop, you really need to think about this, this, and this. You could potentially be walking into a tribunal claim. So I think the most important point is, with dismissal, just speak to a lawyer. In terms of the sort of time periods that are relevant, as a rule of thumb, you can terminate employees within 2 years of the commencement of their employment. So if you've got an employee who is just a bit rubbish, you've had no issues with them, they've not made any complaints about discrimination or anything like that, you can simply terminate them on notice. So you look at your employment contract, they've got a month's notice, you give them a month's notice, and they leave. And that should be relatively safe. You can also terminate people, of course, during their probation period. So the probation period is a contractual period set out in an employment contract. When you're doing your employment contract, you want to set out very clearly the probation period, how long it is, 3 months is standard, and perhaps that you have the ability to extend that probation period by a further 3 months in certain circumstances. You'll often find that the notice period for an employee during the probationary period is shorter, so it's often a week's notice compared to a standard notice during the rest of employment, which is like 1 or maybe 3 months. If you don't have an employment contract, or for whatever reason you don't have notice in your employment contract, which you always should, then statutory notice is a week between 1 month of employment and 2 years of employment. And then for each additional year of employment, you add an extra week up to a maximum of 12 weeks. So when we're looking at wanting to terminate an employee, there are a number of areas that can cause a bit of risk and that we would sort of stop and want to investigate a little bit more closely. The first one is redundancy. So most important point here, if you are getting rid of somebody within the first 2 years of employment and there's no reason for there to be any risk, you would not make them redundant. You would simply terminate them, often without actually giving a written reason. Redundancy has a very specific legal meaning. And in essence, what we're talking about is a circumstance where the business has people who are excess to requirements. And so we need to get rid of that excess capacity. In order to make people redundant, you can't just pick an employee and say, we're going to make you redundant. You have to select some criteria for people who are at risk of redundancy. So you might say to yourself, we have too many salespeople. So anyone who's doing sales, we're going to put at risk of redundancy. So you set your criteria, you then set your group of people at risk. So if it was, people involved in sales, it will be every single person in your sales team, and indeed potentially anybody else who is involved in sales. So all of them are put at risk. And then you apply criteria to decide, who is going to be made redundant. If you don't follow the process in the correct way, you can find that your redundancy becomes unfair dismissal, and that applies even under 2 years. So you do need to be careful. Redundancy really should only be done, well, not only be done, but in most circumstances, it will only be done in respect to people who have been employed more than 2 years, and you will generally want to get, your lawyers involved in understanding how to run that process properly. Any issues with discrimination are automatically something that we are worrying about. So discrimination is applied in respect to protected characteristics. The most common ones are sex, sexuality, race, and disability. On disability, we're not talking simply about people in wheelchairs or people who are physically disabled. We can also be talking about a range of mental health issues. And so in order for a mental health issue to be a disability, it needs to be substantial and long-term, so it needs to be substantial and having a long-term negative effect. Long-term for these purposes is it's applied for 12 months or longer, or it's expected to apply for 12 months or longer. So things such as anxiety, stress can potentially be disabilities. So anything in that space you do need to worry about. It doesn't necessarily mean we can't dismiss, but we just need to be aware of it and have a think about the application and the risks associated with that. Bullying, risky thing. If you've got somebody who's complained about bullying or has been bullied, then you definitely want to be speaking to a lawyer. Pregnancy and maternity, again, risky, very risky area. If you've got somebody who is on pregnancy or has told you they're pregnant or has recently come back from a maternity leave, and you want to get rid of them, then you need to take legal advice. And the final one is whistleblowing. So whistleblowing is essentially where somebody has made a report about something that is either a criminal offence or is something that is obviously in the public interest for it to have been reported. And they believe, or they have been terminated as a result of that report. So that is unlawful. You can't terminate somebody for whistleblowing. What I would say, though, is a lot of employees and actually some advisors think whistleblowing is a lot broader than it is. And so you'll quite often find that, somebody has made a complaint about somebody. They've said, I don't know, this person doesn't explain work to me properly, or this person was rude to a client. They've subsequently been terminated, and they claim that they're protected by whistleblowing because they disclosed that this person was being rude to clients, and they've been fired as a result. Highly unlikely that that's whistleblowing, by the way. There's no criminal offence. It's not in the public interest. So I think if you're concerned about whistleblowing or you've got those sorts of issues, again, talk to a lawyer, and it needs to be dealt with carefully. But there are limitations to how sort of far whistleblowing gets people. So what do we expect to change? So in the interest of political impartiality, I've set out what both the Conservatives and Labour are proposing. I think in terms of the Conservatives, they haven't actually proposed a huge amount, to be honest, in the manifesto. They have made some recent changes in law, though, as obviously the government. So they've made some recent changes to the rights of employees to take time off where they're a carer. So that legislation was passed back end of last year, and it basically gives carers, so people caring for people, the right to have time off. They've also introduced legislation, or passed legislation now, that gives more flexibility to workers over what their working pattern is and how they can sort of best manage that. The government has been trying to pass an Employment Rights Act for quite a while now, which has died when the general election was called. That was actually going to propose to do quite a lot of stuff that I think to some extent Labour have picked up. Weirdly, where the Conservatives seem to have come out in the manifesto is actually moving away from employment protection and moving sort of towards employer protection. So they're talking about changing the sick note system so that it becomes effectively harder for employees to be signed off sick. They're introducing an external third party beyond GPs who are going to verify sick notes. They want to clarify that biological sex is a protected characteristic for discrimination law. And they also want to get rid of a lot of EU law that protects workers. So in simple terms, it feels like an adjustment away from the employment rights legislation they were pushing through that seemed to be promoting employee rights, really moving away from that to reducing employee rights to a degree. In contrast, the Labour Party have talked about in their manifesto the biggest upgrade to rights at work for a generation. And to be honest, what they're proposing is relatively radical. So the sort of key things, there's a lot of stuff in the manifesto about employment rights. I've picked up the things that I think are most sort of relevant to startups and new businesses. So the first one is that they plan to ban exploitative zero-hour contracts. And the crucial word there is exploitative. So they have clarified they're not going to ban all zero-hour contracts. They're just going to ban the ones that are most exploitative. So what they're focused on is giving the right to workers to work a guaranteed minimum number of hours. And that guaranteed minimum number is calculated as an average of the last 12 weeks that they've worked. So what they're trying to do is they're trying to give job security, if you like, to zero-hour workers. If they, in the last 12 weeks, have done a whole bunch of different shifts and they've worked, 40 hours a week, they have the right to work 40 hours a week going forwards as well. What Labour have confirmed is they're not going to prevent paid overtime or fixed term contracts. So to me, this feels like, to be honest, a relatively welcome change. I think zero-hour contracts are something politicians have been moaning about for a long time. they are abused, and I think what Labour are proposing is pretty sensible. They seem to have acknowledged the problems of getting rid of zero-hour contracts entirely. And there was some stuff on TV a couple of days ago with people on zero-hour contracts saying we like them, we don't want to be sort of have them cancelled. So that feels like an incremental change, a big incremental change, but an incremental change nonetheless. They're also talking about ending fire and rehire. So this is where employers, often bigger employers, they basically terminate all of their employees and then they rehire them on lesser terms. At the moment, you can get away with that if the employer has a substantial reason. So the substantial reason is often the company's going to go bust if we don't do this. What Labour seem to be suggesting, as I read it, is they're going to get rid of the substantial reason exemption, meaning that you simply can't hire and refire. Feels like a good thing for workers, but as with all these things, there's a risk that actually it ends up with businesses going bust and therefore employees losing their jobs. So I think it's probably a space to watch as to where, how this plays out and whether actually we end up with some exemptions built into it. And then the bit that I think is most controversial, they have talked about introducing day one rights. So in other words, rights from the commencement of employment for sick pay, parental leave, and unfair dismissal. Sick pay and parental leave, I think probably fine, and I kind of get why they're doing that. Unfair dismissal, I think, is pretty problematic, and I think a lot of employers will be very uncomfortable with it. What they've since suggested is that unfair dismissal won't apply during a genuine, clearly defined probationary period. And I'm not, if I'm honest, quite clear what they mean by that. But I think what they're saying is you can still fire people during probation, but once they're through probation, then they will have the protection of unfair dismissal. Unfair dismissal changes are going to require a load of consultation. So I imagine this is not going to happen quickly. Labour have said they want to change employee rights within the first 100 days of a Labour government. But it seems to me that this one is potentially something that's going to take a while. So maybe 12, 18 months to get that into force. But definitely something to think about. My take on this would be, at the moment, employers can basically get away with giving employees the chance beyond probation. So if you think about, you have a 3 or 6 month probation period, you can terminate on a week. Employees who are okay, but perhaps not hitting the standard, a lot of employers will let it run and they'll take the view, well, look, they flip onto a month's notice. If we can't get them to the standard, we'll fire them before 2 years. I think the risk here is that employers take a much more robust view. If people aren't performing at 6 months or the end of the probation period, they just fire them anyway, to avoid this unfair dismissal protection. So again, potentially a bit of a double-edged sword, that one. So before we take questions, just some sort of final thoughts about things to avoid, or how to avoid some problems. So the first one, check the right to work of all employees. So make sure that the people you're employing have a right to work. Avoid that 10,000 quid fine. Get documentation in place and signed from day one. So don't make the mistake of sending out employment contracts, missing the fact they haven't been signed, and ending up with a problem down the line. As we've talked about, employment law is very likely to change if Labour win this election. And let's be honest, I think the general view is they are. So in terms of employing people today, you really want to get a lawyer to make sure that your employment contracts are flexible enough to build in these sorts of changes. So just taking that probation period point and unfair dismissal, what you want to do is probably beef up your probation period clauses to make it clear that your probation period is for 6 months, but can at your discretion be expanded to, 3 months can be expanded to 6 months, and trying to give you a little bit more flex about how that would work. So yeah, make sure your employment contract is covering what you need to cover. As we just talked about, if the Labour amendments on unfair dismissal come into force, then you probably do want to think about terminating people who are not 100% what you want within that probation period and not letting them go beyond 6 months and therefore having employment protection. Speak to a lawyer before firing people. That's probably the most important outcome, to be honest, of all of this. Firing people can be very simple. It can also be hugely problematic. So speak to a lawyer before you start doing it. Be acutely aware of issues within the business. So you want to make sure, as your business grows, that that your managers, people feeding into HR or to management, they know that if they've got issues or complaints of bullying, sexism, absence due to stress and anxiety, that needs to be escalated, because you need to be aware of it, because you could find, if those issues are not dealt with properly, that you have grievances and potentially unfair dismissal, or you could find that you can't get rid of people because those issues haven't been dealt with. Increasingly new point, encourage an open dialogue in respect of issues such as menstruation and menopause. I think certainly from a male perspective, topics that are very difficult to talk about, and topics I think a lot of employees would want to talk about. Labour have suggested that they're going to build in protection for women whose performance is impacted by these issues. So beginning to think about those issues, what can you do to flex arrangements to make it easier for women who are going through those sorts of problems and are suffering for whatever reason and not able to do their work. Getting on top of that now before legislation comes in, I think is a really good idea. And then the final point, and frankly, the most important point, make sure you have the right work environment. When we see problems that end up in tribunals, a disproportionate number of them come from what people call banter, but which in any other circumstance is unacceptable discrimination and bullying. So those sorts of workplace jokes around homophobic jokes, sexist jokes, racist jokes that I think potentially a lot of workplaces had 10, 15 years ago, that stuff is just a recipe for disaster now and should never, ever happen. So I think you guys have the privilege of setting up a new business, and I think that gives you a lot of control over the sort of work environment you've got. But I think that sort of banter is just unacceptable and is a really, really dangerous thing for an employment law perspective. So stamping it out in the first place and making sure that if you come across it, it is dealt with immediately in a way that everybody's clear it won't happen again. I think that's really, really important. So we do all sorts of exciting stuff above and beyond employment stuff. So all the things on the screen, we do obviously a lot of investment rounds, a lot of sort of corporate commercial work. I think employment is one of those areas that sort of applies pretty much from day one, and you really want to get the right documentation in from day one. So I think making sure that employment stuff is done from the get-go is super important. But we can help with all of the other things there. And if you would like any further information, you can get lots of stuff on our website. We have events every so often that you can attend both in person and online. I wrote a book a couple of years ago which deals with employment stuff and a whole bunch of other sort of topics that are relevant to startups and entrepreneurs setting up businesses. So you can get the first chapter of that on Amazon, and there's generally a discount available. Actually, by the way, outside of my control entirely because it's dealt with by the publishers, but there's usually a discount available for that on Amazon if you would like to get one. Cool. If you've got any questions, please feel free to chuck them into the chat box. Ivan, I think I've seen a couple of questions pop up. Do you want to?
Thanks so much for your time, Michael, and I hope that everyone found the presentation very insightful. Just to let you know, I can see that we have quite a few questions. Guys, if you have more questions, feel free to share them on the chat box. I'm going to pick up a few, and the first question is from Shannon. Shannon is asking, if I want to terminate someone before they have worked 2 years, do I make them redundant?
No, so that was sort of one of the points that I raised earlier. So really, in most circumstances, if you're terminating somebody at less than 2 years, then you're terminating them and not giving them a written reason. So you may have an oral conversation with them and say, in layman's terms, look, it's not working out. But there's then a formal letter of termination that you would send to them, and that shouldn't specify a reason. So it should just say, further to our conversation, we confirm your employment will terminate on this day, and you'll probably explain sort of arrangements to make payments of their final salary. You do not want to talk about redundancy, because if you start talking about redundancy, then you need to have gone through a process, and that creates a load of risk of sort of unfair dismissal and other problems.
Perfect. Thank you so much, Mike. The second question that we are going to take is from Kili. Can I employ people as freelancers?
So yeah, you can. It comes back to this point about sort of control and the nature of the relationship. So you need to sort of think about whether they are really an employee as a matter of law, or whether they're a freelancer. The best thing to do, the government, HMRC on gov.uk have a calculator thing that you can use to figure out whether a relationship is employment or a genuine freelance relationship. So if you Google something like, I think it's disguised employment calculator or freelancer calculator, something like that on HMRC, you can sort of fill in a questionnaire and it will tell you the answer. You can do it on an anonymous basis, in which case HMRC don't know who you are. Or you can do it on a formal disclosed basis. And if you put your company details in, HMRC keep a record of it, you have a record of it, and it gives you a degree of protection if HMRC ever do a subsequent investigation. So yeah, worth using that calculator.
Perfect. Thank you so much, Mike. And guys, I'm going to take one final question because I'm aware of the time. And that question is quite interesting from anonymous user. I read that the label will prevent employees from firing women who have returned from maternity leave. Is this true?
Yeah, so it's a slightly tricky one, that. So what I think they put in the manifesto, but it might have been something that one of the politicians said. I think what they're planning to do is improve protections for women who've returned from maternity leave to make it harder to fire them within 6 months of them coming back. It's a slightly odd one because in practice, you wouldn't want to fire somebody who'd just come back from maternity leave because it would be hellishly risky. You'd really be worrying about sort of discrimination on the grounds of maternity and that sort of stuff. So it's something that most employers would think was a pretty bad idea and would be pretty loath to do. I think what Labour are saying is we want to make it absolutely clear that I guess perhaps what they're thinking is people have been on maternity leave. They're perhaps, out of the business for a period of time. They've lost touch with clients. They perhaps haven't been able to keep up with the way the business has moved, and therefore they're objectively less useful. So when they come back, potentially they're perceived not to perform as well as people who haven't been out for a period of time, and therefore, employers might think they just want to get rid of them. I guess maybe that's the thinking. I think protecting, women to give them a period of time to settle back in is probably objectively a good idea. And so I can see the logic of it. But I have to say, I'm not sure in most cases it changes very much because I genuinely don't think most sensible employers would terminate people, who just come back from mat leave. It would be a pretty risky thing to do.
Absolutely perfect. Thanks so much, Mike. Thank you so much for your time, and thank you so much for everyone joining us. If you have more burning questions, feel free to shoot us an email at office@buckworths.com. Michael will be happy to answer them, and we'll be happy even to set up a complimentary introductory session with him. In terms of the webinar, the recordings of that webinar will be available later on this afternoon on our website. So if you feel that you need to refresh your memory or take some additional notes, or in case you joined later, you can see the recordings on our Insights page on the website later today. We are also very active on social media. We share lots of insights, lots of relevant articles to the startup world and their legal needs. We also host lots of webinars and events tailored to the startup ecosystem. And with that in mind, our next event is in July, Thursday, 18th of July at midday. The webinar is on data protection, and Michael will be discussing everything that you should be aware as a startup, any documentation you need to put in place, how to process personal data. And again, you can ask Michael your burning questions. And Michael mentioned earlier about his book. It was a bestseller on Amazon. Currently, we are running a special promotion for the start of the summer. It's discounted on £10, and you can get that until the end of the month. Feel free to also hit us and follow us on Instagram, Facebook, and Twitter. We share lots of news and updates which are relevant to startups. So thank you very much for your time. I hope that you enjoyed the presentation, and we look forward to seeing you at our next webinar. Bye-bye.
Thanks, guys. Bye-bye.